Imagine spending 5 years of your life meticulously sculpting this massive, breathtaking bronze mural.
Oh, wow. 5 years.
Yeah, I mean, it's an absolute masterpiece. It spans over 100 feet wide, and it was commissioned specifically to sit in the lobby of one of the most important government buildings in your country.
Right, so it's a huge deal.
Exactly. And for decades, it hangs there. It's a symbol of national pride, a testament to your personal genius.
Sounds amazing.
But then a new administration comes in, and they decide, well, the building needs a modern facelift.
Uh-oh. I see where this is going.
Yeah, so without calling you, without even a warning, they hire a demolition crew.
You're kidding.
No, I mean it. They rip your bronze masterpiece right off the wall, they physically break it into pieces, and they just dump the mangled remains into some dusty, forgotten storeroom.
That's devastating.
It really is. Now, you didn't lose any money, right? They paid you for the sculpture 30 years ago.
Right, the financial transaction is done.
Your bank account is totally fine, but when you find out your life's work has been butchered like that, you feel completely violated.
Absolutely. It's your art. It's personal.
So the question is, can you sue the government? Like, can you actually take them to court, not for financial loss, but basically for hurting your reputation and mutilating your art?
Well, the answer is yes.
Yeah.
And it really strikes at the absolute philosophical core of what it means to create something.
Which is exactly what we are getting into today. Welcome to the deep dive.
Glad to be here.
Today's exploration is a custom-tailored masterclass. We designed this specifically for a law student or, frankly, any serious legal enthusiast.
Yeah, especially those of you currently tackling the Osmania University LLB 3-year degree subject.
Exactly. We have a very targeted mission today. We are diving deep into Unit 3 of your syllabus.
Which is the vast, fascinating, and let's be honest, occasionally contradictory world of copyright law under the Indian Copyright Act of 1957.
Right. And our goal is to take these incredibly dense academic notes. I mean, the statutory sections, the exceptions to the exceptions, all those landmark case laws.
And we're going to transform them, make them into a clear, engaging narrative. We want you to walk into that exam room and just absolutely dominate this subject.
But you know, even if we pull back the lens for a moment, even if you are nowhere near an Osmania LLB exam hall, understanding this specific unit is essentially a modern superpower.
Oh, without a doubt. Copyright law basically dictates the entire flow of human culture.
Every video you stream, every meme you share online.
Exactly. Every line of code running on your smartphone, every deep dive you listen to, it's all governed by this invisible architecture.
So understanding the 1957 Act and really how it has evolved is just understanding the rules of the modern creator economy.
It really is.
Okay, so let's unpack this. We have a massive stack of your course materials right here.
And it covers everything, right? From foundational definitions all the way to intricate global treaties.
Yeah, treaties that essentially police the internet. But, you know, to build a house, you need to pour the foundation first.
Right. We start at the bottom.
Before we can even argue about international piracy or drafting a licensing contract, we have to start at the absolute bedrock.
Which is asking, what actually is copyright in the eyes of the law?
Exactly. According to your notes, copyright is a form of intellectual property, and it grants exclusive rights to the creators of literary, dramatic, musical works.
Computer programs, artistic works.
Yeah, cinematograph films and sound recordings. It is a massive, encompassing umbrella.
It is. But notice how the law conceptualizes this right. Your study materials explicitly describe copyright as a negative right.
A negative right? That sounds almost counterintuitive.
I know, it really does.
Yeah.
Because we're so conditioned to view rights as affirmative permissions. You know?
Like the right to speak freely or the right to vote.
Exactly.
Yeah.
The right to assemble. Copyright flips that entire paradigm on its head.
So what does a negative right actually do then?
Well, its primary legal function is not to hand the creator a certificate that says, hey, you made this.
Okay.
Its primary function is a shield. It's the legal power to proactively prevent others from copying, reproducing, or exploiting your work without permission.
Ah, specifically for a commercial end, right?
Right. It is fundamentally the right to say no.
Okay, so when you see that little copyright symbol, the C inside a circle on the title page of a novel or at the bottom of a website,
Yeah,
you are essentially looking at a do not trespass sign.
that's a great way to put it.
A sign planted on an invisible piece of property. It actively stops a competitor from duplicating your effort and undercutting you in the market.
Exactly. But there's a crucial point in your syllabus here, and it trips up a surprising number of people.
What's that?
It's the mechanism of how you actually get that do not trespass sign.
Right, the registration
Well,
process.
that's the thing. The notes state that the creators of these works acquire copyright immediately upon expression.
Wait, immediately.
Yes, it requires absolutely no formal registration to exist.
So the right is just born the very second the thought leaves your brain.
Well, it has to anchor itself in reality. As soon as you fix the work in a tangible medium,
Like if you scribble a poem on a bar napkin.
yes, or you record a quick voice memo of a melody, or hit save on a raw computer script, the copyright legally exists right then and there.
There's no waiting period.
Nope. No government clerk needs to stamp a form to legitimize your creation. Registration is entirely optional.
I feel like people always assume you have to mail something to the government to be protected.
Right, but as we'll discuss later when we get to the Copyright Office, having that registration certificate is highly recommended for evidentiary purposes.
Like if you end up in a lawsuit.
Exactly.
Yeah.
But the fundamental right to say no to a thief, that exists from the very moment of creation.
Here's where it gets really interesting, though. The notes highlight a concept called the idea-expression dichotomy.
Oh, this is huge. If you're taking the exam, you need to underline this, highlight it, put stars all around it.
Yeah, it seems like the absolute central axis of how copyright functions.
It is. The basic rule is this. Copyright law protects the expressions of ideas, but it never ever protects the ideas themselves.
It's like the tightrope the entire legal system has to walk, right?
Perfectly said. The law has to balance rewarding the individual creator with enriching the public as a whole.
Let me try to build out an analogy to make this dichotomy a bit more concrete.
Go for it.
Okay, suppose I have an idea for a story. It's about a young, orphaned boy who discovers he has magical powers.
Sounds familiar.
Right. He gets whisked away to a secret boarding school for wizards. He meets a smart female friend and a goofy male friend.
Okay.
And together they have to fight a dark lord who killed the boy's parents.
Right.
Now, I do not own that idea. That is just a broad conceptual framework.
Exactly. Anyone on Earth is legally permitted to write a story about a magical boy at a wizard school fighting a dark lord.
So if I attempted to sue someone for writing a wizard school book,
The judge would throw the case out immediately. You cannot monopolize the raw concepts of magic or orphans or boarding schools.
but if I write a specific paragraph describing a boy named Harry, who has a literal lightning bolt scar on his forehead,
Right, getting specific.
and he is sitting in a train compartment talking to a red-haired boy named Ron about a sport played on flying broomsticks.
Now we're talking about expression.
Exactly. That exact expression, those specific words, structured in that specific narrative sequence, that is what is fiercely protected by law.
And the rationale behind this dichotomy is literally the survival of human culture.
How so?
Well, imagine a world where ideas themselves could be locked behind a copyright fence.
Oh, wow.
The first playwright to write a tragedy about two star-crossed lovers from rival families would own the entire concept of the romance genre.
Right. No one else could ever write a Romeo and Juliet type narrative ever again.
Exactly. The first artist to paint a bowl of fruit on a table would hold a monopoly on still-life fruit paintings for a century.
We would run out of legal concepts within a single generation.
Completely. Every movie, every book, every song would just be an endless parade of lawsuits because someone, somewhere, had the idea first.
So the law fundamentally recognizes that ideas are basically the building blocks of progress.
Yes, they must remain wild and free in the public domain. That way, every generation can use, mix, and build upon them.
It is only when an artist expends the labor, the sweat of the brow, to take those raw, floating ideas and forge them into a unique, tangible expression.
That's when the law steps in and grants that negative right.
So we have established the bedrock. Copyright protects the expression, not the idea.
Right.
It is born automatically upon creation, and it functions as a negative right to stop others from trespassing.
Exactly.
But what specific actionable powers does this shield actually give you? Like, when you put your pen down and look at your finished manuscript, what exact bundle of rights are you holding in your hands?
This brings us to segment 2 of your syllabus, which explores the dual nature of copyright.
Because the law recognizes that human creation isn't just about money, right?
Right. It is also deeply inherently personal.
Consequently, the Indian Copyright Act divides the author's powers into two distinct categories: economic rights and moral rights.
Let's start with the wallet, the economic rights.
These are explicitly outlined in Section 14 of the Copyright Act, 1957, and your study notes are incredibly thorough here.
Yeah, Section 14 states that copyright means the exclusive right to do or authorize a whole specific list of acts.
Now, the specific rights vary slightly depending on the medium, right? Like whether we're talking about a literary work, a computer program, a film.
Or a sound recording, yeah, but they all share a common commercial DNA.
So for a standard literary, dramatic, or musical work, what are we looking at?
Well, the economic rights include the exclusive right to reproduce the work in any material form.
And crucially, the notes specify this includes storing it in any medium by electronic means.
Which is a huge detail. It means downloading a PDF is legally a reproduction.
Wow, so just saving a file is an act of reproduction. It also includes the right to issue copies to the public, meaning distribution.
Right. And it includes the right to perform the work in public or communicate it to the public via broadcast.
Okay, what about adaptations?
Yes. Section 14 also grants the exclusive right to make any cinematograph, film, or sound recording in respect of the work.
So if I write a sci-fi novel, I alone hold the right to turn it into a blockbuster movie or an audiobook.
Exactly. And it includes the right to make any translation or any adaptation.
So if my book explodes in popularity in India, I own the right to authorize the French translation, the Japanese translation, or to adapt the novel into a graphic novel.
Right. These are the commercial engines of the law. These rights are what allow the author to reap financial benefits from their labor.
And the notes provide a really illuminating piece of historical context here.
Oh, about the timeline.
Yeah. These economic rights have been recognized by legal systems in one primitive form or another since the 15th century.
And that timeline is no accident at all.
Right. It coincides perfectly with Johannes Gutenberg and the invention of the printing press.
Before the printing press, copying a book meant a monk sitting in a room for a year with a quill.
Mass piracy was basically physically impossible.
Exactly. But the moment a machine could churn out 100 copies of a manuscript in a week, the law had to rapidly invent economic rights.
To prevent publishers from just stealing an author's work and bankrupting them?
Yep. Technology basically forced the law to evolve.
So Section 14 is the wallet. It dictates how you pay your rent as a creator.
Right.
But then we flip the coin and we look at Section 57, moral rights.
I absolutely love how the notes frame this part.
Me too. It says, beside their economic aspects, authors are granted moral rights, which enable them to maintain ethical standards, guarantee quality, and protect authenticity.
So if economic rights are the wallet, moral rights are the soul of the work.
And crucially, the text states these rights are personal and cannot be traded.
Section 57 defines two fundamental moral rights. First is the right of paternity.
Which means?
This is the right of an author to claim authorship of a work, and the corollary right to prevent all others from claiming authorship.
So it is the absolute right to have your name attached to your creation.
Right, and to not have someone else's name slapped on it.
And the second one is the right of integrity.
Yes. This empowers the author to prevent any distortion, mutilation, or other alteration of their work.
Or really any other action in relation to it which would be prejudicial to their honor or reputation.
This is a profoundly powerful concept because it operates completely independently of capitalism.
Right. So it means that even if a struggling author sells all of their economic rights under Section 14 to a massive multinational publishing corporation.
Did they sell the reproduction rights, the film rights, the translation rights, absolutely everything in exchange for $1 million?
That author still retains their moral rights under Section 57.
Exactly. The corporation owns the commercial vehicle, but they cannot butcher the text.
They can't rewrite the ending to be completely offensive or publish it under a different name in a way that harms the original author's reputation.
That's exactly right.
Okay, I have to jump in here, though, because I need to flag a really intense, incredibly fascinating contradiction right in the middle of your study notes.
Oh, about the waiver.
Yes. The text says in black and white, no, moral rights cannot be transferred. It treats it as an absolute truth.
Right.
But then, almost in the very next breath, the notes ask, can the author relinquish his or her rights in the work?
And the answer it provides dives into a massive legal gray area.
It really does. The notes are touching upon the highly contested question of waiver. Can an artist voluntarily sign away their soul?
Basically, yeah.
The notes point out that while Section 21 of the Copyright Act explicitly deals with the relinquishment of copyright in general,
when it comes to the specific waiver of moral rights under Section 57, the Indian statute is actually completely silent.
Right. It doesn't say you can, and it doesn't explicitly say you can't. The notes literally call it debatable.
It creates this brilliant collision between intellectual property law and contract law.
How so?
Well, IP law wants to protect the vulnerable artist's soul indefinitely.
Sure.
But corporate publishers and film studios want absolute, unmitigated control over the products they buy.
They want a contract that says we can change your script however we want and you promise never to sue us for mutilation.
Exactly. Now, the study notes suggest that it's legally precarious to try and outright waive moral rights.
Right. If a publisher just puts a blanket clause in the contract saying the author waives all Section 57 rights and promises not to sue.
That clause might actually be struck down by courts under certain sections of the Indian Contract Act for being opposed to public policy.
You can't legally enforce a contract that forces someone to accept the destruction of their reputation.
Exactly. But then the notes offer this wildly pragmatic, almost cynical workaround for the industry.
The severability clause. The notes literally say the best bet would be to draft an agreement with a decent severability clause.
A severability clause basically says, if a judge decides this specific sentence, waiving moral rights is illegal, the rest of this contract is still valid.
Wow. It's the publisher's way of trying to grab as much power as possible while building a legal blast shield in case the court gets angry.
It perfectly illustrates how the lofty philosophical ideals of moral rights have to wrestle in the mud with the practical, ruthless realities of commercial publishing.
And to truly solidify how powerful these moral rights are when they are actually tested in a courtroom, the syllabus brings us back to the landmark case I mentioned at the very beginning of the deep dive.
Ah, yes. Amarnath Sehgal versus Union of India.
This is the textbook undeniable example of the right of integrity in action.
Amarnath Sehgal was not just a hobbyist, right? He was a renowned, internationally acclaimed Indian sculptor.
Right. He was commissioned by the government to create a massive bronze mural for the Vigyan Bhavan.
Which is a premier convention center in New Delhi used for state functions.
Exactly. It took him 5 years to complete. It was a 140-foot span of intricate art.
And then, in the late 1970s, the government decided to renovate the building.
And without consulting Sehgal, without any artistic consideration, they pulled the mural down.
They mishandled it so severely that pieces were broken, parts were lost, and the entire integrity of the sculpture was destroyed.
And they dumped the remnants into a government storehouse.
So Sehgal sued the Union of India.
But the brilliance of his legal strategy is that he didn't sue for copyright infringement in the traditional commercial sense.
No, he wasn't arguing that the government was secretly selling unauthorized miniature copies of his mural.
He sued strictly under Section 57. He argued that the violent destruction and mutilation of his artwork was deeply prejudicial to his honor and reputation as a master artist.
And the Delhi High Court agreed with him.
They did. The court made a profound ruling, recognizing that copyright is a complex bundle of rights.
And completely apart from the economic benefits, the author possesses these special, inalienable moral rights.
The court actually provided a tangible remedy for the infringement of a moral right. They didn't just slap the government on the wrist.
What did they do?
They ordered the government to return the mangled remains of the mural back to Sehgal, and they awarded him financial damages for the insult to his reputation.
The Amarnath Sehgal case proves that an artist really has teeth. They can stop the distortion of their work entirely independent of any commercial incentives.
Your notes also briefly mention another vital case here, ICC Development International Ltd v. RV Enterprises.
Right, and while that case is famous for discussing publicity rights, the Supreme Court utilized the principles within it to reinforce the right of paternity.
Affirming that the right to be attributed as the creator is fundamental and cannot be easily swept aside.
So we have Section 14 and Section 57, the wallet and the soul.
Together, they form the complete picture of what an author holds.
But that raises a massive logistical question, doesn't it?
Yeah, we keep using the word author, but is the author always the owner?
Right. If I hold the pen, do I automatically hold the rights?
What happens when I create something on company time, using company laptops to further my company's business?
This brings us to segment 3, authorship versus ownership.
And the moment we step into the corporate world, things get incredibly complicated.
The foundational rule is found in Section 17 of the Act.
Okay, what does it say?
It states that generally the author of a work is the first owner of the copyright.
That is the default setting of the universe.
Right. If you sit in your living room on a Sunday afternoon and paint a watercolor landscape, you are the author and you are the undisputed first owner.
You hold the wallet and the soul.
But, and this is big, but Section 17 is essentially a giant list of massive industry-altering exceptions to that default rule.
If you are prepping for a law exam, you must memorize these exceptions.
Absolutely. Let's walk through them. Exception A deals with employment by a newspaper, magazine, or periodical.
Okay, let's say you are an author employed under a standard contract of service for a daily newspaper and you write an article. Who owns it?
The notes state that the proprietor, the owner of the newspaper, is the first owner of the copyright.
But with a massive, highly specific limitation, right?
Yes, they are the owner only insofar as it relates to the publication of the work in a newspaper, magazine, or similar periodical.
And in all other respects.
In all other respects, the author shall be the first owner.
Let's create a real-world scenario to show how this works in practice.
Okay.
Imagine you are a staff journalist for a major newspaper in Mumbai. You spend 6 months undercover writing a brilliant, hard-hitting investigative expose about a massive corporate scandal.
Sounds like a great piece.
You type it up and submit it. The newspaper, your employer, owns the absolute right to print that article in their Sunday edition.
To syndicate it to other newspapers, to post it on their news website.
Right. You cannot stop them from doing that, and you don't get extra royalties for it. That is their right under Exception A.
However, let's say your investigative article goes viral. It becomes a national sensation.
Suddenly, major Hollywood studio executives read it and they call you. They want to buy the rights to turn your newspaper article into a 3-part true crime documentary series.
Who gets to sign that massive Hollywood contract and cash the check? Is it the newspaper, because you wrote it on their time? Or is it you?
Based entirely on Exception A, the answer is you, the journalist.
Exactly. The newspaper only holds the copyright for periodical publication. You, the human who actually wrote the words, retain the copyright in all other respects.
That includes cinematograph adaptation rights, book publishing rights, and podcast rights. The newspaper cannot sell your article to Hollywood without your permission.
That is a massive distinction that really protects journalists.
But contrast that nuanced protection with Exception B, which deals with commissioned works.
Right. This exception covers photographs, paintings, portraits, engravings, or cinematograph films made for valuable consideration.
Valuable consideration is a legal term that essentially means an exchange of value. Someone paid you money or gave you something of worth to do the job.
If I hire a professional photographer to shoot my wedding, and I pay them their required fee of 50,000 rupees, I have provided valuable consideration.
So according to Exception B, in the absence of a specific contract stating otherwise, who is the owner?
The person who commissioned the work me, the person who paid the money, is the first owner of the copyright.
Not the photographer who actually framed the shot, adjusted the lighting, and clicked the shutter.
Correct.
Honestly, wait. Let's pause here. Let's really look at this because it feels incredibly unfair to the creator.
I know it does.
If I spend 3 weeks meticulously painting a portrait of someone, utilizing my years of artistic training, the person who merely opened their wallet gets to own the copyright forever.
That's the default rule, yes.
They can take my painting, make 1,000 posters of it, sell them, and keep all the money. Why would the law strip the actual physical creator of their economic rights just because money changed hands? That completely undermines the romantic idea of copyright protecting the artist.
Your frustration is completely valid, and it highlights the ultimate friction between capital and creation that intellectual property law must constantly navigate.
It's all about economics, isn't it?
Basically, the law isn't just trying to protect the romantic artist. It is trying to construct a functioning economy. Exception B exists to protect the investor.
The logic is economic certainty.
Exactly. If a person commissions a portrait or a company commissions an expensive corporate training video, they need an absolute guarantee that they own the final product they just paid for.
Right. If the photographer or the director retain the copyright, they could turn around the next day and hold the commissioning party hostage, demanding more money every time the video is played or the photo is printed.
The law steps in and says, to encourage people to spend money hiring artists, we must guarantee the buyer gets the property.
So if the artist wants to keep the copyright, they have to proactively negotiate a contract that overrides Exception B. The default protects the capital.
It's a harsh reality check. And it goes even further with Exception C, which covers general employment.
Oh, this one is tough. If a work is made in the course of the author's employment under a contract of service, and it doesn't fall under the newspaper or commission rules we just discussed, then the employer is the first owner of the copyright. Period.
If you're a software developer working for a tech firm and you write thousands of lines of code from 9 to 5 while sitting at a desk your company provides, getting paid a monthly salary,
The tech firm owns every single line of that code.
You cannot take that code with you when you quit. You have traded your creative output for a stable salary.
The notes also briefly touch on exceptions D and DD, which follow a similar logic but for the state.
Right. Government works and works created by public undertakings belong to the government or that specific public undertaking.
If you write a report as a government clerk, the government owns it.
But there is one more very specific exception, Section 17cc, which is uniquely interesting.
Oh, this one is great. It deals with addresses or speeches delivered in public.
Section 17cc dictates that the person who delivers the speech, or the person on whose behalf it is delivered, is the first owner of the copyright.
And crucially, the statute states this is true notwithstanding who arranged the venue or on whose behalf the premises were used.
Let's picture a scenario. A massive environmental organization rents out a giant stadium.
They pay for the lighting, the sound system, the marketing, and they invite a famous climate scientist to give a keynote address.
The organization spent millions putting the event together. But under Section 17cc, that organization does not own the copyright to the speech just because they paid for the microphone and the stage.
The scientist owns her words. She can publish them as a book the next day, and the organization can't stop her.
It's an elegant rule that separates the logistical infrastructure of a speech from the intellectual content of the speech.
So looking at Section 17 as a whole, it's all about identifying who holds the initial legal keys to the castle.
Because once we figure out who the legal owner is, whether it's the solitary author, the wealthy commissioner, or the massive tech employer, that owner will inevitably want to monetize the work.
But holding the keys to a castle doesn't put food on the table. To actually generate wealth from this invisible property, the creator has to let other people use it.
How does that exchange work without accidentally giving away the entire castle?
This introduces segment 4 of your syllabus, the mechanics of transferring copyright, assignment versus licensing.
The notes make a really profound point right out of the gate here. They emphasize that intellectual property is fundamentally unique compared to tangible property.
Right. If I own a car and I sell it to you, I don't have the car anymore. I hand you the keys, I walk away, and I lose my rights to it.
But with intellectual property, because copyright is a bundle of rights, even after you assign some rights away, you might still deeply enjoy and profit from the property depending on exactly what specific sticks from the bundle were carved out.
Let's look at the strongest form of transfer first. Assignment, covered under Sections 18 and 19.
Assignment is when the owner disposes of the copyright, either wholly or partially, to an assignee.
If we use a real estate analogy, assignment is selling the house. You might sell the entire estate outright, or you might sell just the west wing.
But whatever you sell, you are transferring actual legal ownership of that specific portion to someone else. The assignee becomes the absolute new owner for those specific rights.
And Section 19 lays down incredibly strict, formal rules for how this transaction must occur. It is not a casual handshake agreement.
No, it must be in writing. It must be signed by the assigner or their authorized agent.
And it has to be exhaustively detailed. It must establish exactly what rights are being assigned. Are you assigning the right to print paperback books or the right to make a movie?
It must establish the duration of the assignment. Is it for 5 years or forever?
And it must specify the territorial extent. Are you selling the film rights just for India or the global translation rights for the entire world?
If you don't spell it out, the law makes assumptions you might not like.
And here is a fascinating piece of statutory protection for creators built right into the system. Section 19A, dealing with disputes in assignment.
Oh, this is such a crucial section.
I read this in the notes and immediately spotted what an incredible safety net it is.
Right. The text says that under Section 19A, the appellate board can revoke an assignment if the assignee fails to exercise the rights assigned to them, and such failure is not attributable to the assignor.
It operates as an anti-hoarding mechanism.
Exactly.
Let me make sure I understand the power of this. Say I write a brilliant, totally original screenplay. I assign the exclusive film rights to a massive movie studio for a large sum of money.
Okay, the assignment is signed, sealed, and delivered. The studio owns the rights.
But then executive leadership changes, priorities shift, and the studio just sits on my script. They put it in a filing cabinet for 5 years. They don't cast it. They don't film it. They do absolutely nothing with it.
Right, it's just shelved.
Under Section 19A, can I actually complain to the appellate board to rip up the contract and get my rights back?
Yes, you absolutely can. The underlying philosophy here is that copyright exists not merely to enrich individuals, but to promote the progress of arts and culture for society as a whole.
So if a publisher buys a manuscript or a studio buys a script and buries it,
Preventing the public from experiencing the art and preventing the author from earning ongoing royalties from its success.
the board can step in.
They will hold an inquiry, and if they find the assignee has unreasonably failed to exercise the rights, they can revoke the assignment, effectively forcing the studio to hand the house back to you.
It's like the government forcing you to sell a house back to the original builder because you left it abandoned and rotting in the neighborhood.
That is a massive protection against big companies shelving creators' works just to stifle competition.
Now, besides assignment, the notes also cover transfer by operation of law under Section 20.
This is pretty straightforward, estate law. If an owner dies without leaving a will, the copyright simply passes to their legal representative as part of their personal estate.
So that covers assignment selling the house. But what about the alternative? Licensing.
If assignment is selling the house, licensing is just renting out a room.
A license is defined as an authorization to do an act that would otherwise be an infringement. It does not transfer ownership.
You are just giving someone temporary permission. You are saying, I own this book. I will give you a license to print 5,000 copies this year, and you will pay me a fee. But at the end of the year, my permission expires, and I still own the book.
The notes divide licenses into two main categories: voluntary and compulsory.
Voluntary licensing is the bedrock of the creative economy. It makes perfect sense. We sit at a table, we negotiate terms, I give you a license, you pay me royalties, everyone is happy.
But compulsory licensing is an entirely different beast.
It really is.
A compulsory license sounds intense. It implies force.
It is a profound intervention by the state into private property rights.
A compulsory license is granted by the Copyright Board in specific extreme situations where the copyright owner of an Indian work has previously published or performed it in public, but then subsequently and unreasonably refuses to allow it to be republished or communicated via broadcast or performed in public again.
Let's play this out. Imagine a legendary, critically acclaimed Indian novel that defined a generation,
Okay.
but it goes out of print. The author passes away, and the author's heirs who inherited the copyright hate the book.
Oh, wow.
Out of sheer stubbornness or ideological disagreement, they refuse to let any publisher ever print the book again. They're essentially holding a piece of national culture hostage. What is the actual mechanism to stop them?
If the work is being withheld from the public detrimentally, an interested publisher cannot just steal it, but they can file a formal application to the Copyright Board.
The board will hold a hearing, allowing the heirs to present their arguments.
But if the board decides the refusal is unreasonable and harms the public interest, the board has the power to force the heirs to grant a license.
The board dictates the terms, fixes the royalty rate the publisher must pay the heirs, and allows the book to be printed.
The state forces the rental of the room to ensure the work remains accessible to the culture.
It is the ultimate balancing act between a private monopoly and the public's right to access culture.
Which perfectly transitions us to segment 5. We keep mentioning this Copyright Board and Appellate Board who actually manages this massive invisible ecosystem.
Who oversees the paperwork, grants these compulsory licenses, and resolves these high-stakes disputes.
Your syllabus outlines a very specific bureaucracy, essentially a three-legged stool of authorities under the Act: the Copyright Office, the Copyright Board, and copyright societies.
Let's look at the first leg, the Copyright Office. This is the administrative hub, physically located in New Delhi.
It is headed by a registrar of copyrights, functioning under the superintendents of the central government, assisted by deputy registrars. Their primary job is handling the registration process we touched on earlier.
And your notes outline the exact procedure a creator must follow. You have to fill out a specific pro forma application.
If there are multiple authors, say a band writing a song together, you file a common application.
You have to pay a prescribed fee, and crucially, you must attach an affidavit swearing that the work is original and not stolen.
The registrar reviews the application, and if all formalities are met, they enter the details into the Register of Copyrights and issue a certificate bearing the seal of the Copyright Office.
And that certificate is vital because it serves as prima facie proof of copyright ownership.
In legal terms, prima facie means it is accepted as true on its face.
If you take someone to court for stealing your script, presenting that certificate means you don't have to spend a week proving you wrote it. The judge accepts you are the owner unless the pirate can definitively prove the certificate is fake or invalid.
It shifts the burden of proof entirely. Okay, I need to pause the legal analysis for a second to give a massive piece of insider advice to you, the listener.
Oh, about the typo in the notes.
Yes. If you are looking at your Osmania LLB syllabus right now, you might notice something bizarre in the section describing the registration certificate. The text gets incredibly garbled. In one paragraph, it literally says, and I quote, "It is registered for life period of the author and 25 years or 50 years period."
Which is confusingly phrased and factually murky.
But wait, it gets worse. Just a page later, under the heading Right of Renewal, the notes contradict themselves, stating, quote, "Copyright is given for 50 years period or during life period of the author and 35 years after that."
Wow. As a law student, you know that standard Indian copyright law for literary, dramatic, musical, and artistic works is generally the life of the author plus 60 years from the year following their death.
And for cinematograph films and sound recordings, it is a flat 60 years from the date of publication.
Right. But you absolutely must be aware that your provided study material has these incredibly specific, somewhat jumbled numbers, 25, 35, 50 years, written down in the text.
This is a classic trap in legal studies. Always, always cross-reference your university study guides with the actual bare act.
The statute is the ultimate truth. Don't let a typo or a poorly translated paragraph in a study guide cost you vital marks on your exam.
An excellent and highly practical warning. Always defer to the exact text of the statute. Now, moving from the administrative office to the second leg of the stool, the Copyright Board.
The board is not just pushing paper. It is a quasi-judicial dispute settlement body.
It consists of a chairman, who must be a person qualified to be a high court judge, and up to 14 other members.
They are the heavy hitters of the copyright world. When massive corporations fight over millions of rupees in royalties, they don't just go to a standard civil court. They often end up before the board.
Exactly. The board adjudicates disputes related to assignment and licensing, and critically, they are tasked with fixing and determining royalties payable for various categories of copyrighted works.
Your syllabus highlights two major cases here to demonstrate the board's immense power over the industry. The first is Gramophone Cone of India Ltd v. Mars, recording PVT Ltd.
Let's break down the facts of that case. Why were they fighting?
This case dealt with the incredibly complex ecosystem of sound recordings and broadcasting. A massive record label owned the rights to countless cassette tapes and audio tracks. Broadcasters wanted to play these tracks.
The dispute centered on how to determine the actual fair royalty rates that radio and television broadcasters had to pay to the recording companies for the right to broadcast that music.
It wasn't a simple infringement case, it was a structural industry dispute. The Copyright Board was called upon to intervene, and their decision established the underlying principles and formulas for determining fair royalty rates in these complex, multi-layered broadcast scenarios.
They effectively regulated the economics of the music industry.
And the second case mentioned is Super Cassettes Industries, LTDV IPRS, the Indian Performing Rights Society.
This was a titanic clash between Super Cassettes, a huge music production company, and IPRS, which is a copyright society.
The dispute was essentially a turf war over who had the ultimate legal authority to collect and distribute royalties for underlying musical and literary works incorporated into sound recordings.
The board had to step in, interpret the act, and clarify the respective rights, obligations, and boundaries of private owners versus collective societies.
Which brings us perfectly to the third and final leg of our bureaucratic stool, the Copyright Society.
The notes describe a copyright society as having a minimum of 7 members, generally authors and publishers, who join together to manage their rights collectively.
The notes say they can grant licenses, collect fees, and distribute royalties.
But I want to understand the actual mechanism. How does a society do this? If I write a hip-hop song, it might be played on 300 different radio stations across India, in 2,000 restaurants, and on a dozen television channels.
Right.
I am one person. I cannot physically track all of that and send invoices for 50 rupees to every cafe playing my song.
And that logistical nightmare is precisely why copyright societies exist. Think of them as massive, legally sanctioned clearinghouses or collective management organizations.
You, the songwriter, assign your specific public performance and broadcasting rights to a society like IPRS. The society now controls a massive catalog of thousands of songs.
Instead of a restaurant trying to track down individual artists to pay them, the restaurant simply buys one annual blanket license from the society.
This blanket license gives the restaurant legal permission to play any song in the society's catalog for the entire year.
That makes sense for the restaurant. But how does the society know who to pay?
Through rigorous data collection, broadcasters and digital platforms provide massive logs of what they play. For physical venues, societies use sampling, digital monitoring, and algorithms to estimate airplay.
The society pools all the millions of rupees collected from these blanket licenses, takes a small administrative cut to keep the lights on, and then uses that data to distribute the royalties proportionally back to you and the other members.
It transforms an impossible logistical nightmare into a streamlined collective economy. And as your notes point out, these societies even have the power to grant licenses for the use of works out of state, managing a nationwide web of rights.
So the Copyright Office handles the paperwork and issues the shields.
The Copyright Board handles the massive disputes and fixes the prices.
And the Copyright Society acts as the union, handling the collective business of tracking play counts and making sure the artists actually get paid. That is a brilliant functioning ecosystem.
It is. Now that we understand the rights, the ownership, the transfers, and the bureaucracy, Segment 6 of your syllabus puts the spotlight on how all of this applies to specific mediums.
And your notes lean heavily into two highly complex collaborative industries: dramatic works and cinematograph films.
These mediums are inherently messier than writing a novel because they involve performance, actors, directors, and massive budgets. Let's look at dramatic works first, defined strictly under Section 2 of the Act.
The definition is quite specific. It includes any piece for recitation, choreographic work, or entertainment in a dumb show, the scenic arrangement or acting form of which is fixed in writing or otherwise.
The operative word there is fixed. If you and your friends improvise a brilliant, hilarious dance routine in your living room, that is not a copyrighted dramatic work. It is ephemeral.
But the moment you write down the choreography steps on paper, or you set up a camera and record the routine, it becomes fixed. It crosses the threshold into a protected dramatic work.
And the owner instantly gets the exclusive rights to reproduce it, perform it in public, and authorize adaptations.
And when it comes to adapting a dramatic work, we arrive at a massive, pivotal Supreme Court case that you absolutely must know for your exam: R.G. Anand v. Deluxe Films.
This case is legendary because it directly tackles the idea-expression dichotomy we discussed in Segment 1, but it tests it in the murky waters of film adaptation. What are the actual facts of this case?
Picture this. It is the 1950s. R.G. Anand is a playwright. He writes a play called Hum Hindustani. The play is a commentary on provincialism in India, specifically exploring the societal conflicts that arise when a man from Punjab tries to marry a woman from a South Indian Tamil-speaking family.
It's a play about regional prejudice and family drama. The play is successful. Sometime later, Deluxe Films releases a major motion picture called New Delhi.
The film also tells a story about a Punjabi boy falling in love with a Tamil girl, dealing with exactly the same themes of provincial prejudice and family objections.
So Anand watches the movie, sees his exact premise on the screen, and sues them for copyright infringement, claiming the film is an unauthorized adaptation of his play.
Precisely. The Supreme Court had to perform a highly complex analysis. Did Deluxe Films steal the general idea of a cross-cultural provincial romance? Or did they steal Anand's specific expression, his unique characters, his specific dialogue, his structural plot points?
The court watched the play and they watched the movie, and they laid down the definitive test for substantial similarity.
What did they rule? Did Anand win?
Anand actually lost. The Supreme Court held that an adaptation of a literary or dramatic work into a film is an infringement, but only if it substantially reproduces the dramatic elements, characters, and structural expression of the original work to the point where an ordinary viewer would say, this is a copy.
However, the court ruled that Hum Hindustani and New Delhi only shared a central theme: the broad idea of provincial prejudice. The film explored that theme with different characters, different subplots, and a different narrative trajectory.
The court firmly reiterated that you cannot copyright a theme. The idea of provincial prejudice is in the public domain. Only the specific script is protected.
It's a masterclass in applying the dichotomy. The notes also bring up Hardev Singh v. Gurcharan Singh.
In this case, the Delhi High Court ruled that merely recording and broadcasting a dramatic performance without the owner's permission constitutes a direct infringement of the dramatic work.
Because a play is inherently designed to be performed, controlling the performance and the broadcast rights is the absolute core of its economic value. If someone records your play and puts it on television, they have stolen your market.
Which leads us seamlessly into the most economically massive medium of all: cinematograph films. Protected under Sections 14 and 51, the law forms a fortress against unauthorized reproduction, distribution, and display of films.
And in India, with the sheer scale and cultural dominance of the film industry, piracy is not just a nuisance, it is a multi-million-dollar battlefield.
The syllabus cites Supercassettes Industries Ltd v. Hamar Television Network. In this instance, a television network essentially decided to broadcast copyrighted films without bothering to acquire the authorization or pay the royalties to Supercassettes.
The Delhi High Court came down with a hammer, granting an injunction to stop the broadcast and awarding significant damages. They sent a clear message that broadcast rights are absolute.
Similarly, in Miss T-Series v. Ma Telefilms, the Bombay High Court was faced with the unauthorized distribution of films via physical DVDs and local cable networks.
A local cable operator was just playing pirated DVDs over their network to their subscribers. The court again ruled this amounted to blatant infringement, shutting it down and awarding damages. The law is designed to fiercely protect the massive financial risk and investment that goes into filmmaking.
Now, I want to ask a clarifying question here based on a very interesting note in the syllabus. The text mentions that alongside the Copyright Act of 1957, the Information Technology Act of 2000 is also heavily utilized to combat modern digital film piracy.
How do those two pieces of legislation interact? If someone sets up a website and illegally torrents a new Bollywood movie, they aren't just facing a copyright lawsuit, they're facing a multi-pronged legal attack, right?
Absolutely. The Copyright Act handles the theft of the intellectual property, the fact that you reproduce the film without permission.
But the IT Act of 2000 addresses the technological means of that theft. It contains provisions regarding unauthorized access to computer systems, data theft, and the circumvention of digital security measures.
So a modern digital pirate is often hit with a dual-layered prosecution: copyright infringement for stealing the expression of the film, and cybercrime violations under the IT Act for hacking servers or distributing malicious code to host the pirated files. It gives the authorities much sharper teeth in the digital age.
Okay, we have spent nearly an hour talking about how to build this invisible fence, who owns the fence, and how to get in massive legal trouble for crossing the fence. We've talked about infringement, unauthorized broadcasting, and the mutilation of art.
But there is a massive vital safety valve built into the very heart of the law, a defense mechanism that actually allows you or me or anyone to take someone else's copyrighted material, cross their invisible fence, and use their property perfectly legally without ever asking their permission.
This is segment 7 of your syllabus. When is it not infringement? The vital doctrines of fair dealing and fair use.
Section 51 of the Act defines exactly what infringement is. But immediately following it, Section 52.1 outlines a massive list of exceptions. And the primary concept governing these exceptions is fair dealing.
Fair dealing is the ultimate balancing act of copyright law. Let's think about the underlying policy. The law grants authors a temporary monopoly to incentivize them to create art and science.
But if that monopoly is absolute and impenetrable, it actually backfires. It stifles education, it prevents news reporting, and it crushes public discourse. Society fundamentally needs to be able to talk about, critique, and analyze the culture it produces.
You can't write a scathing review of a terrible book if the author can use copyright law to prevent you from quoting a single sentence from it.
Precisely. So Section 52.1 carves out specific, limited, legally protected uses that do not count as infringement. These include using a work for criticism or review, for reporting current events in newspapers or broadcasts, for teaching, for research, for private study, and even for reproduction in judicial proceedings.
Your notes highlight two highly specific educational exceptions that are crucial for students. Section 52.1 explicitly allows teachers and students to reproduce copyrighted works for the purpose of imparting or receiving education, provided it is not for commercial profit and does not exceed reasonable requirements.
So if a law professor photocopies 3 crucial pages of a massive legal textbook and hands them out for a classroom discussion on a Tuesday morning, that professor is protected. The textbook publisher cannot sue them for infringement.
And Section 52N provides a similar shield for public libraries and archives. It allows them to make single copies of works specifically for preservation or replacement purposes.
If a library holds a rare, out-of-print 19th century manuscript that is physically falling apart, the library has the legal right to scan and copy it to preserve the knowledge for future generations, regardless of who owns the copyright.
Now, beyond the specific statutory list in Section 52, the syllabus introduces the broader, internationally recognized doctrine of fair use, which relies on a sophisticated 4-factor analysis to determine if a specific unpermitted use is fair or foul.
These four factors are the crucible for analyzing almost any modern copyright dispute, where a creator claims they were just utilizing the work fairly.
Let's analyze these four factors deeply because this is the mechanics of how judges actually make decisions. Factor one, the purpose and character of the use.
The core question a judge asks here is the new use transformative? Did you just copy the original work to avoid paying for it, or did you add new meaning, a new message, or a new expression to it?
For example, a parody is highly transformative because it takes a serious work and subverts it to make a comedic point. Furthermore, courts look at whether the use is commercial or nonprofit. Educational nonprofit uses weigh heavily in favor of fair use, whereas purely commercial money-making uses weigh heavily against it.
Factor 2. The nature of the copyrighted work. The law recognizes that some works are closer to the core of public knowledge than others. The law gives you significantly more leeway to copy from factual informational works like a historical biography charting dates of a war or a scientific article detailing a chemical reaction than it does for highly creative fictional works like a fantasy novel or a pop song.
Facts are adjacent to the public domain. Pure imagination is fiercely protected.
Factor 3. The amount and substantiality of the portion used in relation to the copyrighted work as a whole. Did you quote a single three-word sentence, or did you copy 3 entire chapters?
But judges warn that it is not just a mathematical quantity test, it is a qualitative test. Did you take the heart of the work? If a book is 500 pages long and you only copy one page, but that one page contains the massive twist ending that ruins the entire mystery, a court might rule that taking even a tiny amount is unfair because you took the most crucial, substantial part.
And finally, factor 4, which is often the most critical deciding factor, the effect of the use upon the potential market for or value of the copyrighted work.
Does your unauthorized use act as a market substitute for the original? If consumers can read your fair use version instead of buying the original author's version, thereby causing the author direct financial harm and lost sales, the use will almost certainly fail the fair use test.
Let's run a hypothetical to test these 4 factors in action. Let's say I write a blog reviewing a newly released, highly anticipated sci-fi movie. To criticize the incredibly dark, muddy lighting in the film, I capture a 5-second video clip of a murky scene, upload it to my blog, and write an essay analyzing why the cinematographer failed. Studio sues me. Let's run the test.
Let's analyze it. Factor 1. Purpose. Your purpose is criticism and review. You aren't just uploading the movie for entertainment, you are analyzing it. It is highly transformative.
Factor 2. Nature.
It's a highly creative fictional film, which weighs slightly against you, but it has been publicly released.
Factor 3. Amount.
You took 5 seconds out of a 2-hour film. That is a minuscule quantitative amount.
Factor 4. Market effect.
A 5-second poorly lit clip does not act as a market substitute. No one is going to watch your 5-second clip instead of buying a ticket to the theater. In fact, your clip is embedded in a negative review.
So, applying the 4 factors, my blog post is undeniably fair dealing. I win the lawsuit.
Absolutely. But let's flip the hypothetical to see how the factors destroy a bad faith argument. Let's say I take a highly creative, newly published fictional bestseller. I type out 90% of the text, change the names of the main characters, and release it as a free PDF on my website, claiming I am promoting reading.
Run the test. Factor 1. Purpose. It is not transformative at all. You just copied the text and changed a few nouns. Factor 2. Nature. It is a highly creative work.
Factor 3. Amount. You took 90%, essentially the entirety of the work. Factor 4. Market effect. You are entirely destroying the commercial market for the original book by giving a near-identical version away for free.
You fail all 4 factors spectacularly. It is blatant infringement.
And the courts apply these principles rigorously to real-world complexities. Your notes highlight a phenomenal, incredibly relevant case here. Academic Publishers v. Delhi University from 2012.
This case is fascinating because it touches the everyday life of almost every university student. Let's tell the story of this case. What happened?
It revolves around the common practice of creating course packs. Delhi University professors would assign various chapters from dozens of different, highly expensive academic textbooks. A photocopying kiosk on the university campus would compile these specific chapters, copy them, bind them together into a single course pack, and sell them to students at a fraction of the cost of buying all the original textbooks.
A consortium of major international academic publishers sued the university and the photocopy shop for massive copyright infringement.
The publishers argued, "You are copying our books and selling them. That is commercial infringement. You are destroying our market." How did the university defend itself?
The university relied entirely on the fair dealing exception for educational use under Section 52. The Delhi High Court had to balance the massive financial interest of the publishers against the socio-economic reality of students in India who cannot afford to buy 30 expensive textbooks for a single semester.
And what was the court's reasoning?
In a landmark decision, the court ruled in favor of the university. The court held that the reproduction and distribution of these specific copyrighted academic materials by the university for the purpose of educational instruction constituted fair dealing.
The court recognized that the core purpose was not commercial profit for the photocopy shop, but serving the paramount public interest in education. Furthermore, the court determined that a student buying a compiled course pack of selected chapters was never going to buy the 30 full original textbooks anyway, so it didn't adversely affect the primary market in a way that superseded the immense educational benefit to society.
It is a classic, deeply impactful application of the Balancing Act. So all these intricate rules we have discussed, the economic rights of Section 14, the corporate ownership rules of Section 17, the bureaucratic oversight of the board, and the educational safety valves of Section 52 of Swain. They create a highly sophisticated, carefully calibrated legal ecosystem.
But there is one glaring limitation to everything we have discussed so far. This entire ecosystem only exists within the geographic borders of the Republic of India.
Historically, copyright was strictly territorial. Indian law protected you in India. French law protected you in France.
But the internet and modern commerce does not have borders. If an Indian author publishes a brilliant novel in Mumbai and someone sitting in an apartment in Paris decides to pirate it, translate it into French, and sell it across Europe without permission, how does the Indian Copyright Act of 1957 protect that author thousands of miles away?
An Indian judge cannot send the Delhi police to arrest a guy in Paris.
Which brings us to our final frontier, segment 8 of your syllabus, the global stage and international copyright. Because without a system of international cooperation, copyright in the digital age is practically meaningless.
The notes start by establishing the definitions. Under Section 2(0) of the Act, a foreign work is defined as a work published outside India and not simultaneously published in India, and Section 2(y) defines an international work based specifically on works made by or under the direction of international organizations.
But the true engine that drives this entire global system is the principle of reciprocity, which is enshrined in Section 40 of the Indian Copyright Act.
Reciprocity is an elegant concept. Section 40 essentially declares, India will extend the full protection of the Indian Copyright Act to the works of foreign authors, provided that the foreign author's home country gives reciprocal, equal protection to Indian authors.
It is an international pact of mutual respect. We will guard your artist's property in our courts, if you guard our artist's property in yours. And Section 44 further allows for foreign works to be registered right here in India.
But to formalize this mutual respect across the entire globe, the world had to build a giant interconnected web of multilateral treaties. The oldest, most foundational, and arguably most important treaty mentioned in your syllabus is the Berne Convention for the Protection of Literary and Artistic Works.
India joined the Berne Convention way back in 1928, long before independence.
The Berne Convention, originally championed by figures like Victor Hugo in the 19th century, is monumental. It sets the absolute minimum baseline standards for copyright protection among its member countries.
But its greatest triumph is the principle of automatic protection. Because of Berne, an Indian creator does not need to fly to 180 different countries, hire local lawyers, fill out foreign forms, and register their copyright in every single jurisdiction on Earth.
If the work is created and protected in India, it automatically, instantaneously enjoys copyright protection in all other Berne member states.
That is massive. It creates a unified global baseline that respects the instant nature of creation. But Berne isn't the only treaty governing the globe. Your notes heavily feature the Universal Copyright Convention, the UCC, which was adopted in 1952 under the auspices of UNESCO. Why do we need the UCC if we already have Berne?
The UCC was established primarily to bring into the international fold countries that, for various historical or legal reasons, had not yet joined the Berne Convention, most notably at that time the United States, which had very specific domestic registration requirements that conflicted with Berne. The UCC acted as a bridge.
What are the key architectural features of the UCC?
The UCC champions a revolutionary legal concept known as national treatment.
Yeah.
National treatment mandates that a member country must grant a foreign author the exact same rights and legal protections that it grants to its own domestic authors.
A French court, looking at an infringement case involving an Indian author, cannot discriminate. They must treat the Indian author's copyright claim with the exact same severity and respect as they would treat a French citizen's claim.
The UCC also establishes a minimum term of protection across the globe. Generally, it sets the floor at the life of the author plus 50 years, and it specifically aims to protect those deeply personal moral rights we discussed in Section 57 on a global scale.
To illustrate the profound power of the UCC in domestic law, your syllabus cites an Indian Supreme Court case, Eastern Book Company v. D.B. Modak. In this complex case involving the reproduction of formatted judicial decisions, the Supreme Court specifically analyzed the rights of reproduction through the lens of being consistent with the international principles laid down by the UCC.
The treaty guided domestic interpretation. Your notes also mention a landmark French case, Compagnie des Messageries Maritimes, which explicitly affirmed in a European court that under the UCC, foreign authors are absolutely entitled to equivalent protection to nationals. The system works.
It functions like a legal golden rule enacted across physical borders. But as technology rapidly advanced beyond printed books and cassette tapes, the old treaties had to evolve to keep up with the internet.
Which brings us to WIPO, the World Intellectual Property Organization, a specialized agency of the United Nations.
The notes highlight two critical modern WIPO treaties. First, the WIPO Copyright Treaty, and second, the WIPO Performances and Phonograms Treaty.
The WCT was designed specifically to address the terrifying realities of the digital environment. It ensures that authors have legal control over the dissemination and exploitation of their works online. It explicitly deals with modern issues like digital rights management, DRM, and requires countries to pass anti-circumvention laws, meaning it is illegal to hack the digital locks placed on software or movies.
And the WPPT specifically protects performers' rights globally. The notes explicitly mention a brilliant connection here. The WPPT aligns perfectly with Sections 38A through 38H of the Indian Copyright Act, which grant and protect the exclusive rights of performers, actors, musicians, dancers, and singers, ensuring they aren't exploited when their performances are recorded and broadcast globally.
Furthermore, weaving this all into the global economy, there is the TRIPS Agreement, the trade-related aspects of intellectual property rights administered by the World Trade Organization. TRIPS is the enforcer.
It mandates that member countries must not just have good laws on the books, they must have effective enforcement mechanisms. They must have courts capable of injunctions and customs officials capable of seizing pirated goods at the border.
Which is perfectly highlighted by the final case in your study notes, Microsoft Corporation v. Dhiren Chauger from 2008.
This case is the modern culmination of everything we've discussed. It involved the unauthorized commercial distribution of pirated Microsoft software right here in India.
Microsoft, a massive American corporation, relied entirely on the principles of international copyright treaties and the robust framework of the Indian Copyright Act to seek enforcement against a domestic Indian pirate. The court ruled in Microsoft's favor, highlighting the absolute non-negotiable necessity of robust enforcement measures to combat international software piracy.
When you look at all of this together, the Berne Convention, the UCC, the WIPO Internet Treaties, the TRIPS Agreement, it forms an incredibly complex, deeply interconnected global architecture.
It means that as a creator or as a law student advising a startup tech firm, you have to be intimately aware of these treaties because the battleground for intellectual property isn't just physical books crossing borders and shipping containers anymore. The battleground is digital files crossing the globe in milliseconds.
Modern digital platforms, video sharing sites, global streaming audio giants, massive digital software marketplaces, they rely entirely, fundamentally, on this invisible web of international treaties to function.
Without national treatment and automatic burner protection, these platforms would be sued into oblivion across 190 different jurisdictions simultaneously. These treaties provide the absolute ground rules for the entire global information economy.
Okay, let's take a breath and unpack the immense journey we've taken today, because we have traveled through the absolute heart of Unit 3 of the Copyright Act of 1957.
We started with the foundation, recognizing that copyright is fundamentally a negative right, a shield automatically granted upon expression. We explored the philosophical core of the idea-expression dichotomy, understanding that you own the specific words of your wizard story, but never the underlying concept of magic.
We then split the copyright coin in two, deeply exploring the commercial wallet of economic rights under Section 14, tracing its origins to the printing press, and contrasting it with the deeply personal, inalienable soul of moral rights under Section 57, highlighted by the tragic mutilation of Amarnath Sehgal's mural in Vidyan Bhavan.
We navigated the complex, often frustrating corporate realities of Section 17, figuring out exactly when the employer, the newspaper, or the commissioning party holds the legal keys instead of the physical creator, balancing capital against creation.
We looked at the logistical mechanics of moving those rights around the board, the strict rules of selling the house through assignment, the anti-hoarding safety net of the appellate board, and the mechanics of renting a room through licensing, including the state's power to force compulsory licensing to save culture.
We waded through the bureaucracy of the three-legged stool. The Copyright Office issuing prima facie shields, the adjudicating power of the Copyright Board fixing industry royalties, and the brilliant data-driven collective strength of copyright societies issuing blanket licenses.
We applied all these rules to the collaborative mediums of dramatic works and the heavily pirated film industry, understanding how performance and broadcast rights are fiercely defended, even using the IT Act as a secondary weapon.
We balanced all of that aggressive protection against the vital democratic public interest exceptions found in Section 52, breaking down the 4 factors of the doctrine of fair use that allow for criticism, education, and the life-saving university course packs.
And finally, we zoomed all the way out to the global stage, seeing how treaties like Berne, the UCC, WIPO, and TRIPS create a unified, worldwide net of protection based on the brilliant egalitarian concept of national treatment.
It is an incredibly massive, intricately designed framework. And if you are sitting for the Osmania University LLB exam, mastering these specific sections, these distinct case laws, and these overarching philosophical themes is exactly what you need to succeed. But even beyond the pressure of the exam room, whether you are an aspiring artist, a software developer writing code, or just a citizen trying to navigate the modern digital economy, this legal framework dictates the flow of human culture. It is the invisible fence that surrounds, protects, and sometimes restricts everything we create.
And speaking of that invisible fence spanning the globe, I will leave you with a final thought to ponder, pulling together a few different, seemingly disconnected threads from the source material we analyzed today.
I love a good synthesis to close this out. What are you thinking?
Consider the architecture we've built. We learned that the Universal Copyright Convention ensures foreign authors receive strict national treatment in local courts anywhere in the world. And we also learned that Indian copyright societies have the legal authority to collectively manage rights and vigorously grant licenses and enforce claims even out of state, acting on behalf of their members.
Right. They are a collective powerhouse.
It makes you wonder about the untapped potential of this system. If a relatively unknown independent Indian creator, someone without the funds to hire international lawyers, assigns their economic rights to a powerful local Indian copyright society, could that domestic society theoretically leverage these interconnected global treaties, utilizing national treatment under the UCC and Berne, to suddenly launch and enforce a massive multinational legal strike against a colossal foreign technology corporation operating halfway across the world? The architecture for a global copyright war, fought entirely on behalf of a single, solitary artist in Mumbai against the giant in Silicon Valley, is perfectly quietly laid out in these very notes.
That is a wild but entirely legally grounded scenario to think about. It shows that the invisible fence has some serious world-spanning electricity running through it if you know how to flip the switch. Study hard, trust the Bear Act, and until next time, keep diving deep.